The less the clarity, the greater the arbitrariness, and the greater the chilling effect on people speaking truth to power. When such a jurisdiction is exercised against someone who, may be right sometimes, may be wrong sometimes, as we all are, but works significantly in the public interest and brings a lot of civil liberties cases, then I think the difficult question also, difficult questions also need to be asked as to that aspect of who the alleged contender is. I am not going to comment on this particular case. However, it does seem to me that the jurisdiction of committing of contempt seems somewhat unlimited in a sense. And this view actually was a view that was held also by a Master of the Rolls in England, which is of course where the law of contempt comes from in 1877, in Re Clements versus Erlanger. He said that the jurisdiction of committing for contempt is practically arbitrary and unlimited. That it should be most jealously and carefully watched and exercised, if I may say so, with the greatest reluctance and the greatest anxiety on the part of judges to see whether there is no other mode which is not open to the objection of arbitrariness and which can be brought to bear upon the subject. Well, how do you know what contempt is, right? Is it contempt if I say that cases are being allocated or have been allocated in an arbitrary manner, and that even if it is a case of the alleged assassination of a judge, that there has been arbitrary allocation of who hears that case? Is that contempt? Four sitting judges of the Supreme Court said that. And indeed, one of them then subsequently became Chief Justice. Is the defense of truth something that can even be argued, or will that be further scandalizing the court, as has recently been said? The less the clarity, the greater the arbitrariness, and the greater the chilling effect on people speaking truth to power. And I also do understand that in its absence, courts may feel that they have no other forum through which to speak, whether it's through their, the media or otherwise. But courts speak through their judgments. And when you are the most powerful court in the world, I think feeling secure in that power is important. But in addition, I think, to having restraint when issuing notice for contempt, thereby having a huge chilling effect on, particularly when it's against a lawyer, having a huge chilling effect on all constitutional critique of the court, that there is the need to follow very strict textual due process of law when going through such a case. Once you issue notice on contempt, then everything becomes available. Sending someone to jail becomes available, even if they've apologized, right? Asking them to apologize and retract their statement is something that becomes available. It all becomes available. So of course there's going to be a chilling effect. So I think the lack of certainty is something that already brings in a significant chilling effect on free speech, because then you don't know what it is that is going to constitute contempt and what's not. I think that if had, Sirvai Senior, had H.M. Sirvai been alive, a lot of the things that he would have, that he said would have been thought of as contemptuous. And so, and I have a feeling that he would not have stood down. So what are we saying? Are we going to say that all constitutional comment on the court is going to then be unavailable because of the chilling effect? You see, so the thing is, I think the damage that one is doing to the rule of law, actually, in the absence particularly of a sort of robust mechanism by which to deal with any allegations, but also, free public discussion about what is happening in the court and what is not happening in the court is something to be concerned about. I would like to see, firstly, an institutional and independent mechanism through which, and a transparent mechanism, through which, on the one hand, the probity of the institution can be upheld, and any false toxic allegations can be dealt with through due process. And on the other hand, any true allegations can then find their way through due process to a logical conclusion, and through that logical conclusion, the probity again of the court be upheld through taking action against the particular individual. I think that's the most important thing that I would like to see. The second thing is that regardless of whether the Contempt of Courts Act applies to the Supreme Court or not, something has to apply, right? So a sort of consistency and robust jurisprudence that makes it very clear what is contempt and what is not. It's absolutely unclear now. I think is absolutely vital. And the second thing is that where Parliament has a view, and it's a perfectly reasonable view to say that there should be a truth of defense, a defense of truth rather, and where there should be no contempt, where there isn't a substantial interference in the court of justice, I think due application of mind should be given to that. Now, the third thing I think is that not just in cases of contempt, but in all cases, stringent following of process is increasingly important in these divided times, where there are allegations, all sorts of allegations of political leanings in all directions. So therefore, to make sure that precedent is being followed and that process is being followed, whether it is ensuring that there is sanction by the Attorney General, whether it is making sure that there is the other processes are duly followed, whether all the pleadings are duly considered and carefully considered, etc. The law of precedent is about future insurance of our basic rights. And that future insurance is vital to our continued flourishing as a constitutional democratic